Good morning, everybody. Happy Monday. Welcome to episode 99 of the Courtroom Files Live. We're going to start our morning with Judge Elmore.
Called by taking up the case of people of the state of Michigan versus Andrew Lewis Phelan. This is file number 25-14077FJ. Appearances, please.
Joanna Carey for the people.
Thank you, Honor Taylor and Anna Intervention on behalf of Mr. Fowler, who appears from the RISE program at Ottawa Center via Zoom.
All right, Mr. Phelan, are you able to see and hear me, sir?
Yes, Your Honor.
All right, thank you much. Thank you. All right, we're here today for a request filed by the defense for two evaluations. One is for competency to stand trial. The second is for an evaluation regarding criminal responsibility. The court received about a week ago a motion making those two requests. I don't think I have, not that I expect to have one, but a written response by the prosecution. Did I miss one?
No, you did not.
All right, thank you very much. All right, so we have this motion. Let's go ahead and address just the competency evaluation first. Ms. Fiorabento?
Thank you, Your Honor. So as the court is aware, Mr. Fowler's case began in the juvenile court and then was waived up to this court. Having met with my client via phone and spoken to him, I have concerns about his level of understanding of the criminal system, especially the adult system. It's also my understanding there's a concurrent juvenile matter, and I think there's definitely confusion about the difference between those systems. It's my understanding he was examined for criminal responsibility in the juvenile court back in January, and at the time he was found competent to stand trial. However, his intellectual capacity was quote unquote borderline, and between January and these charges, or the events leading to these charges and these allegations coming about in March, the end of March, it's my understanding there were significant changes in his condition. And that gives me pause for concern if something occurred that would have put him below that standard for competency. I've also asked for criminal responsibility assessment again. When these events were alleged to have occurred, he would have been 17. There was a history of mental illness and other issues. And for all those reasons, Your Honor, as well as just my concerns about whether or not my client fully understands the situation, or why I've requested this evaluation here today. Thank you.
What changes have there been?
Based upon my understanding from the transcripts from the waiver, it sounds like there was allegations of significant drug and alcohol use in that time. And I am not an expert on how that could impact one's ability, but I don't think it's unreasonable to say that overconsumption of those things could have a damaging effect, especially in a 17-year-old. That could be lifelong.
Mr. Phelan, are you still able to see and hear us this morning, sir?
Yes, Your Honor.
All right, Mr. Phelan, I'm going to have you raise your hand, your right hand. Okay, it's the other. There you go. By the way, Mr. Phelan, everyone does that, so don't worry about it. Do you swear or affirm that the information and testimony you're about to provide will be the truth, the whole truth, nothing but the truth, sir?
Yes, Your Honor.
All right, you may lower your hand, sir. All right, your first name again is Andrews, is that correct?
Yes.
And your middle name is Lewis?
Yep.
And last name is Phelan, is that correct?
Yes, Your Honor.
And you are how old now?
18.
And you're currently where again? Something called the Sunrise Center? Tell me about that. What is it called?
The RISE program.
Right. All right, thank you. And do you know which town that's located in?
West Ottawa.
Right. So West Ottawa, got it. And I'm going to ask you some questions. These questions they are not to ask you about what you did in the past. It's just to ask you if you understand the process. All right. Do you understand what the job of a prosecutor is?
Yes, Your Honor.
What does the prosecutor do in a criminal case?
Prosecutor is the guy getting blamed.
I'm trying to give you blame.
Right. Is the guy that did the charges.
Okay, did the charges. All right. Now you have an attorney here, Miss Firavento. Have you met with her?
Not in person, but on phone call.
Okay. Now what is her job in this case?
To fight my charges for me.
Okay. Now, do you know what those charges are?
Yes.
What are the charges that are alleged against you, sir?
Stealing cards, robbing someone's house,
Okay.
a OWI, driving without license, and DUI.
Okay. So, all right. Now, at a trial, there's another group of people that would be in this courtroom. They would be over in those chairs behind me. Those people are called the jurors. What do jurors do in a criminal case?
It help you figure out what you should do.
Okay, that's partly correct. Good, good. Now, do you understand what your rights are at a trial? Did Miss Firaventa go over your rights?
I can't remember, but maybe.
All right, that's okay. That's okay. At a trial, you have the right to testify. What does testify mean?
Um, I've totally forgot what that word means.
It's okay. Now, testify means you would raise your right, like right now, you're testifying. That's where I ask you to tell the truth, and then a lawyer asks you questions, like I'm asking you questions, and then you answer them. Do you understand?
Yes, Your Honor.
Now, Ms. Spiravento throughout a trial is there to help you understand what's going on. What kinds of information do you think she might ask of you?
Lot.
I'm sorry, repeat that last statement. I did not catch it.
All different kind of information.
Okay, all right. Now, these allegations allegedly occurred in Cadillac. Where do you normally live, Mr. Failer?
I live with my dad in Middleton,
Okay, do you know what address that is at?
414 Robert Street.
Okay, good. And that's over by, and I think it's by a little lake up there, is that right?
Yep.
What lake is that?
Great Binnings.
All right, good, good. And have you been going to school?
No.
No, when was the last time you were going to school? Do you remember?
No.
Okay. Do you remember how old you were, or maybe what grade you made it to?
I made it to 11th grade.
All right, good. And what school did you go to?
Middleton High School.
All right, thank you. Now, these allegations, the things that you're charged with, allegedly occurred a few months ago. Do you remember what month they allegedly, they allege occurred in?
March.
Okay, all right, thank you. I'm not going to ask you any other questions about it. Thank you, one moment. Now, in this case, there are going to be some police officers that might testify. What does a police officer do? Just
Okay,
every day.
To help the people to be good.
Okay, all right, that's good. Good answer. Now, Mr. Failer, while you're attending the RISE program, do you actually stay there like overnight?
Yeah,
Okay, and how was that going so far?
good.
Great. Do they feed you?
Yeah,
And are they nice to you?
yeah.
Good, I'm glad to hear that. All right. And what are they trying? I don't want you to tell me what you talk to them about, but I just want to know, are they trying to help you?
Yeah, they are. And it's
All right,
working.
it's working. I'm very glad to hear that. All right, thank you, Mr. Failer. Ms. Ferravento, do you think you have any questions? Because right now I don't see any issue with competency. He understands what the roles are, what without even looking, he can remember his criminal charges. So.
Thank you, Your Honor. There's certainly a great improvement from my last conversation with Mr. Baylor. I would note for the record, he has been in the RISE program for a few months now. He is in step 10 of 15, and I think his conduct here is demonstrative of the good that program is doing. That said, Your Honor, back in March, he was not in this program. He had not received that treatment. And I still would have hesitancy about his level of understanding and abilities back in March as to the criminal responsibility component versus the competency component. Even if he is competent here today due to the extensive treatment he has received, I would still be concerned about whether or not he could bear criminal responsibility back in March. And I did not have the pleasure of meeting Mr. Fowler or speaking to him until after this case was found up to this court. So I really have no baseline to go off of from March versus today.
That's okay. All right. Thank you. Mr. Failer, have you ever had a job?
Nope.
Okay. And what kinds of things do you like to do on your spare time?
Ride bikes, ride longboards, go shopping.
All right. Longboards, those are like skateboards?
Yeah,
Okay, good. Do you ever make your own?
no.
No? All right. I only ask because I think my son has made his own longboard. All right. Thank you very much. Well, the court doesn't find that there's any issue right now of criminal responsibility requiring an evaluation. Mr. Taylor's been able to talk about his age, that he's gone through school, or at least was made it up to the 11th grade. He understands, where he's at, why he's there, what the people are there for, how they're helping him. He understands the charges. In fact, without looking at anything, he recited them. He knew that they allegedly occurred back in March of this year. He also was able to talk about the roles that each one of the attorneys, the judge, as well as the jury play during a trial. I should have asked you this, Mr. Failer. Mr. Failer, when someone is convicted of a crime in a trial, what can happen to them? Do you know?
Go to prison or jail or be on house arrest or be on GPS cheddar.
All right, good. All right, thank you. And so it shows to me now that Mr. Failer understands some of the consequences and options available to the court. Therefore, the court is not going to grant an evaluation for criminal responsibility. However, now turning to the second question. The second question is whether or not the defendant assert a defense of insanity, or which is actually more appropriately called criminal responsibility. The court understands that according to the law, that when a defendant raises that potential defense, he or she has the right for a criminal responsibility exam. Therefore, the court will grant that in order that the defendant is to be examined by the Department of Health and Human Services Center for Psychiatry in Carroll, Michigan. All right. and that'll be at government cost. Anything further today, Ms. Piravento?
No, Your Honor, thank you.
Thank you. How about you, Ms. Carrie?
No, thank you.
All right. Mr. Failer, I want you to understand what today is about. I have two questions presented to me by your attorney. The first question is whether or not I think you need to have what's called a a competency evaluation. I don't think I need to have you evaluated for competency because it means to tell if you've been able to tell me what you're charged with, what the roles of the attorneys and everybody in the courtroom is. So, but your attorney is asking for one called criminal responsibility. Now, some people use a different word called an insanity defense. We don't like to use that word insanity. We actually use a different phrase called criminal responsibility. I'm going to order that you have an evaluation by what's called the Center for Forensic Psychiatry. So someone will meet with you and go over some important questions. Do you have any questions? Do you have any questions for me today, Andrew?
No, Your Honor.
All right. Thank you very much for your time. One more go around. Anything further, Ms. Carey?
No, thank you.
Mr. Avento?
No, Your Honor, thank you.
Andrew, thank you very much for your time. I hope things continue to go well for you there at the Rise Center. Again, they're there to help you, and that's all we want to see happen right now is to help you. Thank you for your time today. We are adjourned.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Monday. I would like to direct your attention to tomorrow, where we will have episode 100 of this show. I can't believe it's 100 already, but I'm going to have something extra super cool, super duper special for you tomorrow. It will completely alter the way that you interact with this show if you choose to participate. It's optional. But tune in tomorrow. We're going to debut that among some other things, so it should be fun. Let's go over to Florida and Judge Mercer.
Probable cause for that charge.
He leído la denuncia y hay causa probable para el cargo.
Mr. Moreno, I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel.
Señor Moreno, le voy a asignar al abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Moreno. He's going to plead of no contest to the charges as listed.
Su señoría, yo hablé con el señor Moreno. Él se va a declarar no me opongo ante los cargos, tal y cual aparecen.
He'll be sentenced to 2 days in the county jail. He'll have credit for 2 days. There'll be a $400 fine, which will be a civil judgment.
Se le condenará a 2 días en la cárcel del condado con crédito por los 2 días que ya ha cumplido. Tendrá una multa de $400 como un fallo civil.
Thank you, Mr. Mitchell.
Very well.
Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Moreno, you do need to understand you have a hold from or a detainer from the United States Immigration Service.
Señor Moreno, usted debe entender que tiene una orden de retención de parte del Servicio de Inmigración de los Estados Unidos.
So if you enter this plea, you will not be released. They have 48 hours to pick you up.
Así que si usted acepta este acuerdo, no se le dejará salir. Ellos tienen 48 horas para recogerlo.
Knowing all of that, sir, is this a plea you would like to enter?
Sabiendo todo eso, señor, ¿quiere aceptar este acuerdo?
Me dice aquí que si me declaro sin oposición, puedo quedar en libertad esta mañana y con la multa de los 400.
Right here it says that if I plead no contest, I can be released this morning with a $400 fine.
You will be released on this charge. You will not be released to the street because another agency wants you.
Usted quedará libre de este cargo, pero no se le dejará salir a la calle porque hay otra agencia que lo está pidiendo.
So I'm telling you, you will be held up to 48 hours for the United States Immigration Service because they have already placed a detainer on you.
Entonces yo le estoy diciendo que se le va a mantener detenido por hasta 48 horas por el Servicio de Inmigración de Estados Unidos porque ellos dieron una orden de retención para usted.
I'm glad to set you a bond if you wish, or you can take the plea offer. Those are your choices.
Si usted lo desea, yo le puedo poner una fianza o puede aceptar el acuerdo. Esas son las opciones que tiene.
If I set you a bond and you post it, you still will not get out onto the street. You will still be held for the United States Immigration Service.
Si yo le pongo una fianza y usted la paga, como quiera, no lo van a dejar salir a la calle. De todas formas, lo van a mantener detenido para el Servicio de Inmigración de Estados Unidos.
Do you have any questions?
¿Tiene alguna pregunta?
No.
No.
Do you wish for me to set you a bond, or do you want to take the plea offer your attorney has negotiated?
¿Desea usted que yo le ponga una fianza o desea aceptar el acuerdo que su abogado negoció?
Acepto el acuerdo. Tendría que esperar 48 horas. Si ICE no viene, yo quedaría libre.
Okay, I'll
Así
take the
es.
plea. So I'd have to wait 48 hours, and if ICE doesn't come, then I'd be released, right?
That's correct.
Es correcto.
I'm going to accept your plea of no contest to the charge of no valid driver's license.
Acepto su declaración de no me opongo ante el cargo de no tener licencia de conducir válida.
You have a question before further?
Antes de proseguir, ¿usted tiene una pregunta?
Solo para quedar en claros, aunque me ponga fianza y la pague, no puedo salir.
And just so I'm clear, even if you were to set a bond and I paid it, I still wouldn't be released.
For 48 hours, that's right.
Por 48 horas, correcto.
Ya, ok, está bien. Para quedar bien claro, si pone fianza y la paga, no puedo salir, y así el acuerdo que hizo el abogado, con el acuerdo que hizo el abogado ahorita pasaría lo mismo, ¿verdad? Estaría esperando y si no viene por mí, quedaría libre.
Okay, and just so that I am completely clear, so if you set a bond and I paid it, I'm not released. With the attorney's agreement, is the same thing. I still have to wait, and if they don't pick me up, then I can be released.
I cannot make it any clearer than this. You're not going anywhere because the United States Immigration Service says you're here illegally. That's as clear as I can make it.
Ya no se lo puedo explicar más claro. Usted no va a ningún lugar porque el Servicio de Inmigración de Estados Unidos dice que dio una orden de retención para usted. Eso es lo más claro que se lo puedo explicar.
Do you want to accept this plea, or do you want me to set you a bond?
¿Quiere aceptar este acuerdo o quiere que le ponga una fianza?
Acepto el acuerdo.
I'll take the plea.
Okay, so I'm going to find the plea that you've entered is freely and voluntarily with the advice of counsel.
Voy a determinar que ha aceptado el acuerdo libre y voluntariamente con consejos de un abogado.
I'm withholding adjudication of guilt and sentencing you to 2 days in jail.
Le suspendo el fallo de culpabilidad y lo condeno a 2 días en la cárcel.
I am giving you credit for the 2 days you've already served and imposing the fine of $400.
Le doy crédito por los 2 días que ya cumplió y le impongo una multa de $400.
You're through with that case and you will not be held for Jackson County any further.
Ya terminó con ese caso y ya no se le mantendrá detenido de parte del condado Jackson.
But as it's been explained to you at least 3 times, you will be held 48 hours for the United States Immigration Service.
Pero como le he explicado por lo menos 3 veces, se le mantendrá detenido por lo menos 48 horas para el Servicio de Inmigración de Estados Unidos.
Do you have any questions?
¿Tiene alguna pregunta? No.
No.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Mr. Ricardo.
Thank you, Your Honor.
Next case is Nicholas Tyndall. Mr. Tyndall, good morning. Mr. Tyndall, you're here because you've been accused of felony driving while license suspended. You've also been accused of violation of state probation. Mr. Tyndall, I'm going to appoint the public defender's office to represent you for first appearance purposes. I'm going to tell you that there is probable cause in the complaint. I think you're entitled to a bond in one case, but not necessarily in the other case. But let me listen to the attorneys before I make a final decision. Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Tindall, I'm going to set your bond on the felony driving license suspended at $10,000 cash as surety with a condition of no driving an automobile at all, period. And you've got no bond for 10 days on the violation of probation. I'm asking Mr. Mitchell to notify the probation office of your arrest. It's case 21-198CF. And Mr. Tindall, you're pretty close to getting off of probation, really close. It appears.
Yes, sir.
So normally they file a violation if there's a new arrest. Now, whether or not they will ask the judge for a notice to appear or a bond, I have no idea. And then whether or not what the judge will do, I have no idea. So Judge Garcia can say, give him a notice to appear on the VOP because he's so close to getting off. Or Judge Garcia can say, I'm going to issue a bond. Or Judge Garcia can say, I'm going to issue no bond. That's what we're waiting the 10 days to see. Any questions, Mr. Tindall?
No, sir.
Have a good day, sir.
All right.
Alante Bellamy. I think he had done, it's off in October and he'd done 3 or 4 years with no violations. I think that's right. Mr. Bellamy, good morning. You're here because you're accused of 1 count of trespass. Mr. Bellamy, I'm going to appoint the public defender's officer to represent you, sir, and ask that you listen to Mr. McDaniel, your attorney, and he's going to tell us if this is a plea agreement or if there's a bond analysis.
Your Honor, I spoke to Mr. Bellamy. At this point in time, he's going to plead of no contest to the charge of trespassing. The understanding he's going to be sentenced to 4 months in the county jail. He have 1 day jail credit, $370 fine. And he is going to waive his right to a jury trial and call witnesses. Mr. Groves, I don't think I had him sign that plea waiver form. If you would have him sign it. Also, Mr. Egg. Okay. I did go over it with him, but I talked to him about it, but I didn't. Okay.
Thank you. Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Mr. Bellamy, did you hear that agreement?
Yes, sir.
Mr. Bellamy, any questions about that agreement?
No, sir.
And Mr. Bellamy, is that the plea that you would like to enter?
Yes, sir.
Mr. Bellamy, I'm going to accept your plea of no contest to the charge of trespass. Going to judge you guilty, sentence you to 4 months in jail, give you credit for the 1 day you've already served, order court costs and fines of $370. Mr. Bellamy, there's no probation involved in this sentence. When you finish this jail sentence, you're through with this case, and hopefully you can get in the trustee program and get you some extra gain time. You probably did that last time you were in jail, so hopefully you can do that again and get out a little quicker. Mr. Bellamy, I wish you the best. Do you have any questions?
No, sir. Thank you.
Yes, sir. Have a good day.
You too.
We have Vernis Newton. Mr. Newton, good morning. Mr. Newton, you're here because it appears that you're wanted in 1 state and 2 different counties. What I've got is you're wanted in Vanderburgh County, Indiana, and Dearborn County, Indiana. I know that you've had a chance to speak to Mr. McDaniel about the waiver of extradition process. Mr. Newton, do you have any questions about that process?
Just how long do they have to come get me?
They have 30 days starting the day you sign that waiver in front of a judge. So starting today, they have 30 days. Mr. McDaniel, you satisfied he's doing this freely and voluntarily?
Yes, yes, Your Honor.
So you're signing 2 waivers because there are 2 counties, I believe. Mr. Newton, what we do in Jackson County is we review the cases at 15 days simply because I want to know where things stand and I want the defendant to know. So if you're still here in 15 days, you come back to first appearance, I'll ask the jail what the status is. You'll get to hear their answer. If you're not here, then you're already gone. If you are here, you'll get an update then. Any questions?
Thank you, sir. Thank you.
Wish you the best, sir. And I believe that's it for first appearance purposes. Is there anyone else that's in the courtroom now who's here for someone at the jail? Okay, so
Charles Neal.
he's on the docket. this morning?
No, he's a pretrial case, but I was going to try to go ahead and resolve his case.
Okay, we need the jail though.
No, we don't need the jail.
Corporal, I think that's it as far as I know. Corporal Drown, anything else from the jail this morning?
No, Your Honor, that was it.
All right, and Mr. Mitchell from the state with the
Nothing.
jail at least?
Nothing from the state regarding the jail, Your Honor.
Mr. McDaniel?
Nothing, Your Honor.
Corporal, we appreciate it. We'll see you tomorrow.
Okay, so since they've wrapped up there, let's go to Wisconsin, and Judge Mogan is about to do a sentencing hearing.
Matter 24 CF 137, State of Wisconsin versus Eliza Mitchell. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Mitchell appearing in person with her counsel, Jacob Gondik. We're set here today in this matter for a sentencing portion of this case. Ms. Mitchell did plead guilty on April 4th, 2025. to operating with restricted controlled substance as a first, as a forfeiture, and homicide by negligent operation of a vehicle. The court ordered a pre-sentence investigation report. The court has thoroughly reviewed that report and the recommendations. The court has also reviewed the alternate PSI prepared on behalf of Ms. Mitchell and defense. In my review, although I am not as familiar with all of the facts that could be contained in the file and about this matter, I did not find any material facts or corrections that would need to be stated on the record. But we are in victims' rights compliance. We have victims here. We're going to have at least 4 victim impact statements. Mr. Schmidt, did you receive and review both the PSI and the alternate PSI?
I did. I reviewed them. I have 2 corrections to the PSI. That is the DOC one. First, they put the wrong date on when the offense happened. They wrote it happened in 2025. It did not happen in 2023. The second correction I have is they indicated that the blood results for alcohol were 0.02. It was not. It was less than 0.02. That is all.
Oh, right. I did notice that date as well. I just didn't highlight it, so it didn't jump out. I did have it circled. As to the lesser than 0.02, I was not definitely aware of that matter. Thank you. Mr. Gondik, any corrections or modifications for the record?
No additional corrections or modifications other than the ones already stated by Mr. Schmidt. Thank you, Your Honor.
Did you thoroughly go over both of these documents with Ms. Mitchell?
I did, Your Honor. We had an opportunity to review both pre-sentence investigation reports, the DOCs and the alternate, and went over those with Ms. Mitchell, answered any questions she has, and I believe she has a full understanding of both of the documents, Your Honor.
All right, thank you. Ms. Mitchell, you thoroughly did go over these documents with your attorney?
Yes, Your Honor.
And you did not notice anything other than perhaps those 2 corrections that would be necessary for the court to be aware of?
Yes, Your Honor.
Okay, thank you. All right, victim impact statements, please. Ms. Bauer, can you please have each of them? They can all come and sit right here behind the little victim table, and then they can come up one by one. If you can please have them identify themselves either by their full names or by initials, whatever they feel the most comfortable. I would appreciate that. Thank you. Well, they can sit all back there. Yep, just so I know and I can see and I can pay attention. Thank you. All right, again, please either state your name or your initials for the record. You can have a seat, pull the microphone close to you so that we all can hear. And I know that this is a very emotion-filled matter and case. And I know that there's a lot of emotions running through everybody right now. I'm going to please ask each of you that if you're going to be reading something, please read it very slowly. If this is something that's going to and it causes a lot of emotion. If you're going to be filled with emotion, you can take a breath and stop. I need to be able to hear and understand everything very clearly, okay? All right, you may begin.
Your Honor, my name is Deborah Matrios, and I'm here speaking today as the mother of Katrina Gail Matrios Staples. I wrote this statement to describe how the reckless choices made on the early morning of October 4th, 2023 have changed my life. Since losing my daughter, I have struggled every day. No parent should ever have to bury their child. It goes against the natural order of life. The grief that followed Katrina's death was and still is overwhelming. The pain is indescribable. I continue to experience intense waves of anxiety, depression, and anger. My relationships with my family and friends have suffered, and I often find it difficult to connect with the world around me. Even simple tasks can be unbearable. One of the hardest parts is that the accident occurred just 3 miles from my home.
I'm having a very hard time, and I just need you, I understand that I really, truly, I'm very sorry for your loss. If you can speak up, and try and enunciate just a little bit more, please.
One of the hardest parts is that the accident occurred just 3 miles from my home. I pass that location often, and each time I do, the images in my mind are vivid and haunting. There is no escape from the place where my daughter's life was lost. Katrina was and always will be my greatest blessing. Her smile could light up any room. She was kind, compassionate, and genuinely caring. She had a rare gift. She made everyone around her feel seen, heard, and appreciated. The world feels darker without her in it, and the void she left behind is impossible to fill. I not only grieve losing my child, but I mourn the grandchildren I will never meet. The moments I will never share with her as a mother watching her own children grow. I will not get to see her walk down the aisle, celebrate her milestones, or hear her laugh as she tells me stories about her own family. Those dreams died with her, and there's an ache in my heart for the generations that were never given a chance to exist. That loss is invisible to others, but I carry it every day. I respectfully ask the court to recognize the devastation this tragedy has caused, and I hope that in time I can find the strength to rebuild, to feel joy again. Nothing can bring my daughter back, however. Justice must be served for the life that was taken and the pain that remains. I urge the court to impose the maximum sentence for the crime the defendant chose to commit. Thank you for allowing me to speak respectfully, Deborah Matras.
Thank you so much. All right, the next individual, please.
My name is Katrina Hawkins. Katrina Matrias was my cousin, but she was so much more than just family. She was my best friend. We grew up side by side, supporting each other through every stage of life. We shared countless memories, laughter, comfort, and everything in between. On the morning of October 4th, 2023, I was getting ready for work when I received a frantic phone call from my mom. She told me that Katrina had been in a car wreck and did not survive. I remember standing there in disbelief, saying out loud to myself, "It's not true. She's okay. She's not dead." I kept repeating those words as I continued my commute to work. It wasn't until I sat down at my desk that reality began to set in. I realized I was in denial. Losing her has been one of the most painful challenges I've faced. Katrina was full of life, and she had the kindest heart. She was always looking out for others and lived by the principle of giving without expecting anything in return. She truly was the kind of person who would give you the shirt off her back. A memory that stands out was when Katrina, my cousin Alex, and I were having breakfast at the Poor House in Siren. Katrina had asked the waitress for another table's bill because she wanted to pay for it. I remember Alex turning to her and saying, "Wow, you make me want to be a better person." That was the kind of light Katrina brought into the world. She inspired those around her with not just words, but with action as well. This world was robbed of someone who made it a better place. Recently, I graduated from college. It was a proud moment in my life, but it was also bittersweet. The pain of knowing Katrina wasn't in the crowd cheering me on, like I know she would have been, was difficult. She was always one of my biggest fans, always lifting me up. Every year without fail, She was the first person to wish me a happy birthday. It was something small, but it meant everything. Now that message won't come again, and that's just one of the many quiet ways her absence is felt. The bond I shared with Katrina was unique. She was someone I could be completely myself around, no masks, no fear of judgment. We had this effortless connection, the kind where just a glance could send us into a fit of uncontrollable laughter. Being with her felt like home, and I miss that more than anything. The reckless actions that caused this tragedy didn't just take her life, it took a piece of who I am. No sentence or punishment can bring her back, but I hope the court considers the weight of this loss, not only to me, but our entire family and community. Thank you.
Thank you. Good morning, everyone. My name is Ashley Matrias. I'm here to elaborate on how the choices made by Eliza Mitchell on October 4th, 2023 has affected me and my family and how it's changed our lives forever. I will slow down. You just slow down, please. I know that this is, it causes a lot of anxiety. Just take a breath and let me know exactly what you want me to know. First, I'll tell you the kind of person she was. Katrina was a happy soul full of positive energy. She was always willing to help anyone, especially those she loved. She had a heart of gold. Family was everything to her. She took care of her cousins like they were her own children. When she met my firstborn, I was taking a shower and my sister was about to change him when Katrina stopped her and showed her how to warm the wipes with your hands before wiping their butt. I was so impressed by her motherly instincts at 16 years old. At that point, I knew I was going to ask her to be my kid's wetness. A wetness is the Native American version of a godparent. I was honored that she accepted because I trusted that if anything happened to me, that my kids could call upon Trina for anything. Katrina was amazing. She was the only one in my family who would just show up to visit and spend time with me and my kids for my son's golden birthday. She saved up money to fly not only herself, but 2 cousins out to Pennsylvania and surprise my son. No one asked her to bring them, but out of the goodness of her heart, she left them with some of the happiest memories that will last a lifetime. She never missed a birthday and never showed up empty-handed. Her and my daughter Paisley had a special bond. They called each other Chicken Wing. My children and I always enjoyed the time we got to spend with Katrina. She was our person, someone we could count on. She helped me in so many ways, from babysitting, cleaning my house, joining us at the park, bringing us out to eat, or just hanging out at the house, playing games with the kids. I can't forget the times she would help plan, shop, and decorate for my kids' birthdays. She was so much more than a cousin or a best friend. She was my soulmate. She lifted my burdens and helped me through life's challenges. She didn't always know what to say, but her presence said it all. It breaks my heart that she will never have the chance to have a baby, a family, get married, and grow old. I'll never get the opportunity to hold her baby and watch her flourish as a mother. Her mother no longer has a chance at becoming a grandmother. Any future plans Katrina had, from being a mother or continuing her education, was ripped away from her by Eliza's choice to drink and get behind the wheel of a motor vehicle, even though 8 days prior, she was given a citation from Burnett County law enforcement for underage drinking and still made the choice to drink and drive. The last time I seen Katrina was Sunday, October 1st, 2023. It was my daughter Paisley's birthday. Everything was normal. Katrina was running late. I remember she showed up with a smile and delivered Paisley's gifts. We hung out, had some laughs, and said our goodbyes and parted ways. 3 days later, I received the dreaded 6 a.m. phone call that broke my heart. Three days later, I received the dreaded 6 a.m. phone call that broke my heart and changed my family's life forever. My mom called saying Katrina's been in a car accident and she died. I remember right after I hung up, I grabbed my tobacco, I ran outside, and I remember standing at the end of my driveway and the clouds giving an eerie vibe, the way they were moving, but it wasn't windy. I tried to carry on with my day as usual, but once I arrived at work, I couldn't focus. I couldn't speak without crying.
I left work early and took the rest of the week off to be involved with the planning of the funeral. My children were close with Katrina and I knew they could feel I was not okay. I had to find the strength to tell my kids that Katrina had died in a car accident and we would never see her again. It was a difficult thing to do. It was emotional as Paisley didn't understand and wanted to know why. It was time to start planning a funeral. This was my first funeral to be involved with. Native American funerals have a specific timeline when and how things need to be done. It's a very strenuous, emotional, and stressful process. The pain I felt laying my cousin to rest was unbearable. It felt like the clothes I was wearing was suffocating me, getting tighter, and the pain in my chest felt like a heart attack. I continue to feel the pain. Some days these feelings flood over me. And the simple question, how are you, was just too much for me. I stayed at my mom's in Danbury during the funeral time, and I remember how beautiful the sky was at dusk every night when we got ready to have a feast and a meal with Katrina. It was breathtaking. After we laid Katrina at her final resting place, it was time for me to return home. As I get ready to lay down and go to sleep, I could feel the toll it took on my body. My bones ached. I was emotionally and physically exhausted. I lay there and reflect on the week and how that was it. Never ever again would I get to see her, hear her, or hug her again. It was time to resume back to my normal life, which was difficult because Katrina was my person who I talked to on the daily, whether it be a phone call, a text, or a Snapchat. I no longer had my best friend to share the good times with or vent to get through the tough times. After her funeral and leaving Danbury, I didn't realize how traumatic it would be to return or how much it would sadden me each time I pull into Danbury knowing I won't see her. There was so many times I would sneak to Danbury to steal Trina for a couple of days, or maybe just for a couple of days, or maybe just for a few other hours. Either way, it never felt like enough time. I have avoided Danbury and skipped some family events because it hurts to watch my family having a good time without Katrina. Not only have I avoided Danbury, but I have avoided family members because they can't heal them, and I don't know how to deal with the pain it has caused our family. Katrina used to bring us together. She loved every one of our family members. I have two stories for you. One time we were crafting and she grabs my blank calendar and starts writing birthdays. She had almost every single one of our family members' birthdays memorized. And one night we were chilling at my house and she realized it was one of our younger cousin's birthdays. So she called her cousin Des and asked to speak to the birthday girl, and we sang happy birthday. It was in moments like this that happened often with her. She would spread happiness to every person she could. There is many occasions where we'd be out to eat and she would pay it forward and pay someone else's bill. After she passed away, so many people would come to share their stories and memories with me. Not one, not a single soul had anything negative or bad to say about her. Katrina was an amazing person with a heart made of gold. She filled this world with laughter and happiness. Ask anyone, they would tell you the same. If you needed anything at all you had to do was ask, and she was there. Eliza Mitchell made a choice to get behind a wheel of a motor vehicle after drinking, 8 days after getting a citation for underage drinking. I strongly asked the court that she get the maximum sentence of 10 years for homicide by negligent operation of a motor vehicle. Imagine reading a book with no way to turn back the page. How carefully would you read it? Let me put this in perspective for you. Katrina's book is done, over, no more pages to write. No amount of time, punishment, or tears can bring Katrina back, but Eliza continues to write her book. Thank
Tell
you.
me about the feast. I don't know, I know this much about.
At a funeral, the day they die, you have a feast that night at dusk, and every night until the funeral, you eat with her.
And do you eat their favorite foods?
Yes.
And what was Katrina's favorite food?
She really liked the Red Lobster biscuits. There's one, but she had many.
Thank you, and thank you for sharing those memories.
Thank you.
Good morning, everybody. My name is Ward Staples. I'm Katrina's father. The morning, October 4th, 2023, will forever be one of the most absolute worst days of my life. As a 16-year active member of Danbury Volunteer Fire Department, I've seen the worst of the worst. But the morning of this tragic and totally preventable accident will go down as the worst I have ever seen. That morning, Danbury Fire was paged out to a motor vehicle accident 2 miles south of Danbury. I responded to this accident, not knowing what I was about to see. Walked up to the crash scene, and my life changed. My life changed forever. It was a complete nightmare when I realized that the victim laying there was my daughter. I stood there and watched CPR in progress, and any first responder knows how violent CPR is. I can still see her face. I can see her eyes. To this day, I relive that crash scene in my mind, day after day. Nothing's going to take that away. Took me a long time to be able to talk about this. Counseling, friends, my family helped me. Still, I break down and cry every time. I'm gonna miss her. She used to call me all the time. Say, hey, Pops, what are you doing? We'd like meet, talk, tease. She was very funny. And I loved her very much. So I ask, please impose a prison sentence, please. Probation's not enough. Thank you.
Thank you. Thank you all very much. You can go have a seat in the back. Ms. Bauer, is that all who will be providing a statement today?
Yes, Your Honor.
All right, we will now turn to argument from the state. Mr. Schmidt.
Thank you, Judge. I'm going to be recommending consistent with the pre-sentence investigation with one deviation. As the court recalls, I'm bound to cap at the PSI. However, the way the PSI writer framed the conditional jail, they did not give a determinate amount, and they suggested staggering it in a way that I don't think is a good idea. So I'm going to be suggesting the conditional jail should be upfront, not staggered over 4 years. I'm also going to leave my recommendation of the conditional jail to be indeterminate because I don't want to violate the plea agreement because DOC also left it indeterminate. So for what they did put there, I do think the court should recommend I am recommending the 4 years probation, 2 years initial confinement, 1 year extended supervision, stayed and imposed. And then I think the court should do an upfront conditional jail sentence. The sentence in this case must be driven primarily by 3 factors, I would say. The court's heard a lot from the victims about punishment. There's a need to punish Eliza Mitchell because of the tremendous impact on all the people whose lives the victim has touched and was connected to, and the horrors that they have had because of this incident. Imagine getting a call as a first responder and seeing your daughter is the victim. Next is general deterrence. I don't normally argue general deterrence, but I think it's specifically necessary in this case, given what caused this crash and the lack of public awareness about it. And I think there's a flippancy with a lot of the public to not take it seriously. And third, rehabilitation of the offender. The PSI noted this is a low-risk offender with no criminal history. There is a goal to rehabilitate this person, no matter what. Even if the court deviated from what I argued and did a max sentence, she'd be getting out sooner rather than later. So we need to be thinking about rehabilitation. So I'm going to talk first about what this offense is, because there are statements in the PSI and statements from the victims that would imply this is an alcohol or drug-related homicide. It is not. There is a reason the police did not arrest Eliza Mitchell on that night. It's because she didn't show sufficient signs of impairment. When the blood came back, it showed she was not impaired by alcohol or THC. There was a small amount in her system, but the amount was so small, it affirmatively showed she was not impaired by it. That's why the state never charged an actual OWI, because she did not lack the clear judgment and steady hand to operate a motor vehicle. What caused this crash is something that kills countless people in Wisconsin and other states every year. You probably see signs about it by the road constantly, and people just ignore it, and that's distracted driving. What caused this crash is Eliza Mitchell was driving 80, 81 miles per hour. We know this because every vehicle has a black box. When you crash, it records what led up to the crash. She was going 80, 81 miles per hour, quite a bit in excess of the speed limit. She got out her phone, which she herself admitted, and while she was looking at her phone, she started to go off on the shoulder, which tracks with the black box data, which showed the vehicle started to lose traction as it drifted. And then somebody hard jerked the wheel, causing the crash. Those things together caused the crash. The speed, the drifting and starting to lose traction, and the hard jerking of the wheel. You put those things together, that is what killed this victim. That is what caused somebody's death. And I think the reason why I think the victims wanted to fixate on the idea of an OWI homicide is I think everyone kind of accepts OWI homicides are serious. It's choosing to impair yourself and getting behind the wheel and driving. Too many people don't take seriously that distracted driving is just as dangerous, kills just as many people. That's why we see increasing public attention to not using your phone while you drive. And when you think about it, it really emphasizes the senselessness of the death, because somebody died just because somebody wanted to look at a phone or text something, and that seems so horrific. And that's part of what goes towards general deterrence and punishment here. The public needs to be made aware of how dangerous distracted driving is. There's not enough public awareness. The court should follow this agreement because the public does need to be alerted that this will be treated with the seriousness that it's merited. The punishment aspect too, that's why I think the conditional jail should be up front. The DOC kind of recommends something contradictory in the PSI. They tell the court, hey, judge, you shouldn't do an upfront prison sentence because Eliza Mitchell's already taken a lot of steps. She's already made a lot of advancements. She's showing remorse and guilt. So sending her to prison now would detract and derail from those successes. And then they recommend a conditional jail structure where for the next 4 years, regardless of how well she's doing, she's going to go to jail for however many days. Whether she's doing good, whether she's doing bad, doesn't matter. That doesn't make sense. The purpose of conditional jail in this case would be for punishment and for specific deterrence of this individual. We know that that makes the most sense up front when it's actually connected with the pronouncement of sentence. That's when it has the strongest specific deterrent effect. And that's when the punishment is most closely connected to the sentencing, to when the judgment conviction is done. I do think there are cases where structuring the conditional jail as DOC recommends might make sense. That would be cases where I'd say the offender does not have remorse, does not have guilt, is not accepting responsibility, because then you would basically make them throughout the probationary sentence suffer that on those dates, basically making someone feel remorse, even if not for their actions, for the sentence. That doesn't make sense with this offender in this case. It should be upfront. It should be conditional jail. The court needs to do conditional jail because not doing any incarceration at all, I think, would unduly depreciate the seriousness of this offense. It would unduly depreciate the suffering of her family, her friends, the victim's friends and family, and all those people's whose lives she's touched. To her benefit, she does have significant rehabilitative need. That's why DOC is saying don't do prison up front. She's shown a lot of remorse and advancement prior to the PSI even being done. In fact, it's arguable that the alternate PSI done by the defense argues a harsher sentence than the DOC even. And this is consistent with even law enforcement observed this prior to the case being charged out, is she had already taken strides to correct her life in the wake of this. And it's significant that nothing has happened in the years since this occurred. This happened in October 2023. We're coming up on August of 2025. This is a low-risk offender who's been law-abiding for almost 2 years now. That's something to consider for rehabilitative potential. That's probably why the DOC went with probation. As the court's aware, the court always has to consider probation first. DOC, being required by the legislature to focus on evidence-based decision-making, is going to focus on rehabilitation rather than punishment, specific deterrence, general deterrence. So that's the basis of my recommendation. I think the court should do the long end of the probation, the long end of the initial confinement, and the ES they recommend. It should do conditional jail. It should be upfront. I should add, the reason I'm saying the 2 years initial confinement instead of the one that DOC recommends is I'm assuming the court's going to do conditional jail. It would make no sense to do less than 2 years initial confinement on a state imposed sentence if the court's going to do conditional jail, because the conditional jail time counts towards credit if they're revoked. So if the court did that, you'd wind up in a weird situation where if Ms. Mitchell did get revoked and the court followed the DOC's recommendation, did conditional jail, she'd wind up probably not going to prison at all. She'd just have time served off of the initial credit from conditional jail and sitting awaiting revocation prior to the revocation of the ES or the probation occurring. So that's why I think the court should go on the high end of the initial confinement. Thank you.
Thank you. Mr. Gondik?
Thank you, Your Honor. Would first point out there actually is quite a few things that, well, certainly it's not a joint recommendation to the court. There are a lot of things that, as defense counsel, I can say we agree upon with the state and would mirror many of the things that DA Schmidt just stated. Our position, Your Honor, is we'd be asking the court to impose a sentence of 18 months initial confinement, 1 year extended supervision, that being stayed for 4 years of probation. And then ultimately leaving it up to Your Honor as far as if they'd be following the DOC's recommendation of having jail around the anniversary, or what that means entirely as far as if it's a weekend structure or a longer period of time every year. And then also in the alternative, if this honorable court's not going to agree with that anniversary type conditional jail structure, we would ask that any upfront conditional jail time be structured where Ms. Mitchell could potentially have the monitor. I can tell you, as far as my due diligence, I have reached out and have it coordinated where she would be eligible for the monitor, provided that this honorable court would grant her that opportunity, whatever that upfront amount of time would be. I would, obviously there becomes another punitive aspect for it before people think that the monitor is essentially a get out of jail free card. Obviously you are being monitored as to your every move, every location. You are not free to move about as you will. And there's another punitive aspect is obviously the financial aspect. My understanding is the minimum of $25 a day to even have that opportunity to be on any sort of electronic monitor here in Burnett County. I Another thing I would note, just as far as the DOC recommendation goes, with this anniversary type conditional jail, I did reach out to Ms. McDowell to try to get additional clarity, and she wasn't willing to provide any sort of recommendation as to the actual length. She just wanted to leave it up to your honor. So I did double check on that. When looking at the Gallian factors here that the court must essentially make their determination on, obviously the first thing we look at here is the gravity of the offense. This is a felony G. We obviously acknowledge the seriousness of this. I mean, there was a life loss. There is no doubt as to that this is a serious action. I think Ms. Mitchell is well aware of how serious this is. With that being said, when overall looking at this crime, I mean, there's not a specific intent element to this. Obviously, this is negligent. This is not an intentional act. This is, as Mr. Schmidt said, a distracted driving case. This happened when Ms. Mitchell was 19 years old at the time of the offense. Yep, certainly an absolute terrible idea to choose to drive. She didn't have a driver's license, never had a driver's license, and realistically probably never had the resources to get a license, as far as what we've heard by reading the PSIs, as far as kind of her social background and family background. Being 19 years old, obviously her brain was not fully developed at the time of making this choice. This was an immature, impulsive decision that obviously Ms. Mitchell has drastically learned from in the last 2 years. Moving on to the character of the offender, Mr. Schmidt kind of pointed out, but obviously there's a very strong rehabilitative need for Ms. Mitchell, and that's where this focus and emphasis should be. There is an absolute plethora of character letters that were provided to the court. I tried to limit, I think there might approximately be 6 or so from different individuals that obviously say good things about Ms. Mitchell, whether that be as a mother, recently has a 1-year-old little boy, which sounds like she's getting glowing reviews from everybody as to her ability to parent and be a mother, as well as her character as a hard worker, working at the St. Croix Casino. She's been juggling that along with, as far as the rehabilitative part of this, juggling work along with being a mother, completing group therapy for substance abuse, doing individual therapy to focus on her mental health. A big part of that is coming directly from her provider, which a letter was filed with this court and was sealed as to the progress she's made and really the glowing reviews that she gets as far as the steps she's taken since this action. I would also note that the timing is very important. A lot of times when defendants come before a court, it might be 30 days before suddenly they start, going to treatment and doing actions that try to bolster their position at sentencing. That's not the case here. Ms. Mitchell has been actively involved in this treatment for well over a year. She's done the legwork. She pulled herself up by her bootstraps. She's taken random hair follicles just based off wanting to show that she is sober of all substances. She's been clean. She's been doing everything she possibly can to take care of herself. Another thing when looking at the character of Ms. Mitchell in this case, Your Honor, is the responsibility. I think it can't be overemphasized, the responsibility she's taking. We're not coming to court today to ask Your Honor to don't impose any prison, just do 30 days jail, anything like that. We're not trying to downplay the severity of this. This case has never been set for a trial. She pled out, obviously the length of these cases sometimes certainly can take a while given the severity, but she's never downplayed this. She's already paid the OWI fine from when she was sentenced on April 4th. All the financial obligations are taken care of. She's obviously been very respectful to this court. As far as I'm aware, she has no missed court appearances, no warrants ever issued for her, showed up on a summons. She essentially, she's always acted appropriately in court. and she's really takes it serious. She showed up at a bail revocation hearing or potential bail revocation hearing. I can't remember the date specifically, but towards the end of April, where she knew there was a good chance she could be put in jail, and she continued to show up and to take this serious. As far as a very important factor for the court to consider, well, certainly not one of the three in Galleon, but remorse. I can't think of a situation where somebody could possibly be more remorseful. Every day, she deals with this. This is not something you just move on from. She deals with the grief. But not just every day. Part of my due diligence as a defense attorney is to review all of the discovery material in every single case. I watched the video, I watched the audio, I watched the CPR being conducted on Miss Matris. And one thing I can tell you is the remorse from Miss Mitchell didn't happen after she got charged with the offense. It happened the moment, as from the earliest I could see on any sort of body cam footage, from when law enforcement showed up. She was screaming at the top of her lungs, hysterical, trying to ultimately, she couldn't take the news that Miss Matris was deceased. This was in fact, without question, 100% an accident that Miss Mitchell feels absolutely awful for and deals with it every day. No criminal history. There was an underage ticket that was referenced. Obviously, being 19 years old, not a good idea. Pled guilty to that, or I forgot if it was default or guilty, but regardless, paid the fine for the underage ticket. Has no actual criminal misdemeanor or felony history whatsoever. When looking at the next element, or excuse me, the next factor in Galleon of the need to protect the public, I think it's very important to look at the crimogenic risk factors that are stated in the DOC's PSI. Of the 16 factors that are referenced in there and scaled essentially to low, unlikely, likely, probable, whatever the ranges may be, 11 of the 16 came out low or unlikely on the assessment for recidivism. Of a couple of them that were considered to be high or likely, when looking at cognitive behavioral thinking and substance use, those are being addressed, and they've been addressed for over a year now. And they're going to continue to be addressed as a condition of probation. I really think it's incredibly important, the information that Ms. Smith has stated in her letter that is sealed with this honorable court, as to the progress that Ms. Mitchell has made, leaps and bounds as far as mental health wise, and obviously staying sober. In summary, as far as dealing with the need to protect the public, the overall risk was a 3 out of 10. It was very low. When looking at deterrence, obviously this court has to look at a general deterrence and also a specific deterrence provided to Ms. Mitchell. Generally, what this court is saying is I would have to agree with Mr. Schmidt. If you have an imposed and stayed prison sentence of any length hanging over an individual's head, and this isn't a one-size-fits-all. I would imagine the circumstances of the recommendation are going to be totally different if somebody shows up, takes no remorse, takes no responsibility, and does nothing to deal with any substance abuse or mental health issues in the interim from the time they're charged with the offense to the time of sentencing. But from a general standpoint, it's still very serious to know that you would have an imposed and stayed prison sentence, a hammer over one's head, to be able to say, if you are revoked on probation, you are going to prison. Prison is not something that's taken lightly. And as Mr. Schmidt said, it's obviously the rehabilitative needs, and looking at probation is first, prison second. Ms. Mitchell has a plethora of rehabilitative needs that are and will continue to be addressed moving forward. In addition, as far as specific deterrence, the same goes there, as there would be this hammer over Miss Mitchell's head as far as, hey, you would be going to get shipped to Dodge Correctional and ultimately enter the Wisconsin prison system if you get revoked on probation. So I think the issues of general and specific deterrence in this case, Your Honor, are covered as far as that it would not unduly depreciate the severity of the offense here. To kind of wrap up the overall argument before you hear from Ms. Mitchell herself, I would note that I thought the PSIs overall, both writers did a really good job explaining how they came to the recommendations that they did. That's why ultimately we are asking the court, and Ms. Mitchell is asking this honorable court, the opportunity, and it is just that, an opportunity to be on probation for 4 years with 18 months of initial confinement and 1 year of extended supervision imposed in state. And once again, asking if Ms. Mitchell were to be out, stay in the public, continue to be rehabilitated, that she would have the opportunity to be on the electronic monitor so she could continue to work, go to treatment, be a mother to her child, and ultimately not be around people in jail that potentially might be high risk. We're all aware of what happens if you put a low risk offender with people that are generally more serious or high risk offenders. It can actually have a total adverse reaction as to the low risk offender. So with that being said, Your Honor, that is our recommendation. If the court has any questions, I'd be happy to address them.
I saw statements in the letter from the medical professional, which has been sealed, but I have reviewed that. I've reviewed all of the documents filed, the character references, the character letters, and the medical professional letter. I'm seeing inconsistencies in the fact in the medical record, it states that she has abstained from THC use since September of 2023. But in the PSI, and I think in both the PSI and the alternate PSI, Ms. Mitchell has stated that she has abstained from THC use from the end of October 2023. So I'm seeing inconsistencies there as to how long she has really abstained from THC. And I thought I recalled in the facts of the case, at least as outlined in the PSIs and or the criminal complaint, that the night of the accident, she may have had a puff or two of a joint, but I need to make sure that I'm understanding the facts correctly.
No, I don't know.
Your Honor, addressing this with Ms. Mitchell, she, based off her memory here today, cannot remember specifically an actual date as to the last use of THC. She believes it to be right around the time of the accident, whether it was a day or two before or right around that time frame. I think the inconsistencies, however they came about here, I would note, regardless, we're looking at almost 2 full years of sobriety, taking that into consideration.
I do understand that, but I need to understand the night of the incident and what we're talking about there. Am I recalling incorrectly? I can't, and I'm trying to review to see if there was any THC use, whether insignificant, small, whatever, the night of the incident. because I do understand what's stated by Mr. Schmidt and the district attorney's office, as well as what's in the PSI, that there was some detected and it was minimal. However, I need to have my brain fully understand the facts of the case. Was THC consumed that night, even in a minuscule quantity?
I honestly do not remember that night, but I know that there's like a Delta 8, Delta 9 cartridge that has been used either the day before or that morning. So.
Okay, all right. Anything else you want to add, Mr. Gondek, before I move on and ask Ms. Mitchell for a statement if she wishes to provide one?
No, Your Honor.
All right. Ms. Mitchell, I'm going to give you an opportunity right now to let the court know anything you want me to know. You don't have to provide a statement, but again, it's your time to reflect on this incident, to address any remorse, to let the court know any difference in facts that there may be or that you have heard here today. Again, you don't have to, but it is your only opportunity.
Yes, I will.
And if you're going to read something, please read it slowly. And I understand, I see that you're filled with emotion right now. Please make sure that you enunciate your words so that I can understand them as well as the court reporter.
Okay. I wanted to start off saying that I deeply apologize for the loss that I caused, and I take full responsibility for my actions that took place that night. I understand the seriousness of my actions and the impact they have on this family and the community. I truly wish I had done something differently that night, and I'm not here to blame anyone else but myself for my actions. And I'm so very sorry that I didn't think more clearly and more safely. My intentions were never for this to happen, and I was wrong for making a decision so big. I always think, could I have done differently? And there's a lot I could have done, and I wish I could go back and do those things. I also know that I can't change the past. However, I am committed to learning from it. And doing everything in my power to grow into a better, more responsible person, not just for myself, but for my family, my community, and my child, and everyone who is counting on me. Once again, I deeply apologize for my actions and for the pain and grief that I have caused. Since that time, I've stayed committed to my recovery and building a stable and healthy environment for my baby and I by attending weekly therapy sessions, staying sober, and surrounding myself with positive influences. During my time in therapy, I have noticed changes in my character. I've become more patient, more open to my emotions, and it's always been a safe place to help me work on my emotions and through the trauma that I have experienced. I truly am grateful for the progress that's been made and for being able to develop healthy coping mechanisms and learning to communicate my emotions properly. I've maintained a steady employment to provide financially. I've held myself accountable and stayed disciplined even when things get uncomfortable or challenging. I've been doing everything I can emotionally, mentally, and physically to keep my life moving in a more responsible direction. Staying sober has also provided me with a more clear mind. It has helped me make a stronger connections and relationships with my family and my peers. And for that, I am very appreciative for the support system I have developed. Next, I'd like to talk about becoming a mother. The love that I have for my son is immeasurable. I've cherished every moment with him so far. However, I could not fathom the loss of anyone's child. And that is a pain I pray to never endure. And it's something too heavy for me to fully grasp or understand. I do understand the love, but I will never understand the loss. And I am truly sorry. I respectfully ask the court to consider a sentence that will allow me to continue the progress I've made and remain present in my baby's life. I understand the consequences of my actions, and I'm not asking to avoid accountability, but rather an opportunity to continue proving that I'm capable of lasting change. Whether that includes house arrest, probation, or continued treatment, I'm committed to fulfilling any conditions the court sees fit while staying focused on my recovery and responsibilities. Thank you, Your Honor, for giving me the chance to speak and for taking the time to listen to my words. I truly appreciate the opportunity to express my remorse, my growth, and my commitment to a responsible future. I understand the seriousness of my actions. That's why I'm pushing so hard to become better, not for only me, but for my son. And your time and consideration means more than I can express.
Thank you. First and foremost, the court, and I'm sure all of the court officials in this room, offer condolences for the loss of Katrina. She sounds like a remarkable young lady who was taken from this earth way too soon. Way too soon. I have gotten the pleasure to hear about her through not only the information contained in these documents that I have and that I've reviewed many times, but through the victim impact statements. She sounds and appears to me to be a person who, when they walk in the room, it just becomes a brighter place. That she was an individual who, as it has been stated, has a heart of gold and who would have done anything for anyone, even without being asked. I don't believe I've heard from anyone, including Ms. Mitchell, that she has or had a negative flaw, that she was combative or confrontational. The words that I have heard about Katrina have shown her to be an incredible woman who has been taken, again, far too soon. I do not want to see the loss of her be in vain in any way. A case like this and other cases, perhaps with losses, they're not easy for the court. I am, as all other judges are to be robots. I hear the information, I have it inputted, and then I need to process that and then to spit it out in a form of a sentence. It is not to be an emotional process for the court. I am to be rational. Although this is a very emotional day for everybody inside this courtroom. I have said this before and I will say it again because if I could, I certainly would. I wish I had a magic wand and I could turn that wand and turn back time and change the outcome. The outcome from that very tragic day of October 4th, 2023. Nothing that I say and nothing that I do and no sentence that I give here today or I render can bring back Katrina. I wish it could. Katrina lives in her family and friends. Katrina lives in those stories that are told over and over again at the family functions and to our children and to our friends. Katrina's memory is bright and beautiful. I really wish I could take away the pain. And I hear and I've heard a lot of anger and frustration. And I'm not saying that that is wrong. We are human. And I have no clue. I cannot even imagine the pain that the family is feeling. I cannot imagine feeling the horror of that day or having my heart feel like it's being ripped out of my chest. I cannot imagine the pain of a father coming up to an accident and doing what he's done for 16 or so years in helping to save people's lives and helping to help those who are in dire need, and to come up to this very tragic accident only to see it is his daughter laying there. And knowing, as he stated, how horrible and how hard it is for a body to have CPR done to it. Knowing what happens to a body when you're trying to revive it and seeing it is his daughter. I never want to experience that personal pain in my life. And I feel for the family and the friends and everyone going through this pain. I have heard from Miss Mitchell, and I have also read in the documents that Katrina was her friend. Katrina's loss has impacted Miss Mitchell as well. It has impacted her family. The facts of this case are very tragic. To have such a tragic death occur 3 miles from your home and to have to drive by that scene multiple times a week or even a day, and knowing that every time you drive by that, your heart sinks to your stomach and it gets ripped out of your chest, figuratively, every time. As Katrina's mother stated, it is now a dark world for her, and her void, the void of the loss of Katrina, cannot be filled. It can never be filled. This is perhaps one of the worst kind of tragedies, because at first blush, this does look like an operating while impaired type of case. Ms. Mitchell did admit to, and it was detected in her system, to have alcohol when she was 19 years old. And she did have in her system chemical components of THC, marijuana. But as the state indicated, this was not enough in her system for the alcohol under 0.02 or the chemical components of THC to impair her driving. So this has to be looked at differently. Although it was a choice to have any sips of alcohol while under the age of 21, and it was a choice to consume THC at whatever level, at whatever time. And as I've read in the PSI document, it was an understanding of Ms. Mitchell that with regards to THC, that sometimes people think that THC is a medicine, and that in some cultures, it is not looked upon as a drug or an illegal substance. But it is. Whether it's used in ceremonies or culture is one thing, but in the state of Wisconsin, any detectable amount of an illegally controlled substance, including THC, while operating a motor vehicle is a crime. Whether or not it did impair Ms. Mitchell's driving, it was in her system and it is illegal. Whether or not the alcohol in her system impaired her driving, she was not of age to consume any. And now we have the death of a very beautiful young woman who will never be able to marry, who will never be able to be a mother, who will never be able to achieve the accomplishments that she could and be who she was to be. But we have her memory, and we cannot let that be soured. We cannot forget the tragedy. When a court sentences an individual for crimes, there are certain things that I have to look at. Both attorneys address them in general. The court has to look at how serious is this matter, the nature and the gravity of the offense. Everybody agrees this is extremely serious. A life was lost. Whether it's from any consumption of alcohol or THC, or here we have distracted driving, cell phones. Every person who is behind a wheel, a vehicle should note that and should not allow that person to be able to view or see texts or messaging or anything of that nature. Some people even say telephone calls. I'm sure everyone in this room has an understanding of what a cell phone does and how it distracts a driver. And we have a night where there was weather issues. We have extreme speed, 80 to 81 miles per hour. We have Ms. Mitchell driving a vehicle that she was not familiar with. We have Ms. Mitchell driving without a driver's license, without ever having went through and completing a driver safety course and taking the exams to be licensed. Multiple things here, multiple things that are adding up. They are choices. Every one of these was a choice. This was an accident, but it was an accident that could have been avoided. Second, the court has to look at the defendant and her character, her past criminal record, and look at her rehabilitative needs. We have lost a life, but does the court look at losing or significantly harming another life? And now we have a baby involved that was conceived after this incident. Whether the baby was an unexpected blessed accident or unplanned pregnancy, whether the baby was planned, and if so, that in it of itself is selfish. Or was the baby planned not only to perhaps take away the pain of Miss Mitchell that she is feeling from the accident, the guilt that she is feeling from the accident, but the court has to look, was this baby conceived to try and avoid punishment? The baby is also a victim. Because no matter what the court does, he did not choose and he did not do anything to be responsible. The third thing the court has to consider is the need to protect the public. And here this is partly about the victims and their feelings and their emotion and their tragic loss. But it is also largely about the rest of us, the community, the people who live in this community and in this state. And in looking at the public, I have to look at one of the factors that Mr. Schmidt hit on, and it was echoed by Mr. Gondik: deterrence. Not only specific deterrence to specifically deter Ms. Mitchell from any further action or conduct like this, to deter her from continuing to make such negative and poor choices, but general deterrence so that the public can be deterred from similar type behavior. The court cannot determine if one of those factors and negative choices alone caused the accident, if it's a combination of all together, whether Ms. Mitchell herself is fully responsible, or whether the individual who grabbed the steering wheel and caused the vehicle to swerve and to lose control is partly to blame. We have lost a life that cannot be brought back, but there are lessons that can be learned to protect the public in the future. I have reviewed the pre-sentence investigation report very thoroughly. I've reviewed the alternate PSI. I have reviewed the character letters and the mental health professional assessments. I've heard the statement of the victims and that impact, as well as the impact on Ms. Mitchell. It's unfortunate, beyond unfortunate, this case. And it makes me recall, I believe it was 2015, the loss of the 3 Milltown Angels, those 3 little girls that died tragically in the vehicle when the mom/aunt was distracted by her telephone. 3 little girls died that day. Just as Katrina died this day. Ms. Mitchell is taking responsibility. She has pled guilty to a very serious crime. It will forever be on her record and in her past of homicide by a negligent operation of a vehicle. That will forever be part of her story. Now, what you do with that story, Ms. Mitchell, is completely in your hands. You can continue to better yourself. You can continue to be a better community member, a better Native American. You can continue to be a better mother, a better friend, a better auntie, a better person. Or you can totally throw it out the window, if not today, some day in the future, and sour memory and loss of Katrina. This will forever be on your shoulders, and it is your choice every single day to continue to live and better Katrina's memory or to tarnish it. My higher courts have advised and directed me that I must first look at probation. Unless confinement is needed to protect the public from Ms. Mitchell and further criminal activity, unless she needs correctional treatment that she can only receive in an institution that she cannot receive in the public, or if probation would unduly depreciate the seriousness of the offense. And if I am to order confinement, either with probation or a straight incarceration sentence, I must order confinement at an amount as minimum as possible, which is consistent with the protection of the public, the gravity of this offense, and rehabilitative needs of Ms. Mitchell. I do applaud and commend Ms. Mitchell for the actions she's taken since the date of this incident to correct things in her life, to address her mental health, to address substance abuse issues, to understand consumption of alcohol and illegal substances, anything that can impair your ability to fully think properly or to operate heavy equipment or a vehicle. She has done many positive things since this date, October 4th, 2023. The court looks at those positive things that you have done, Ms. Mitchell, but I also need to look at the negative things that you did leading up to the loss of Katrina. Because this is about punishment as well. And it is about deterrence as well. And I do also have to take in your past and the traumas that you may have experienced and what may have led up to your choices that day. And you had a very unstable childhood. Again, you are in a place where you can take control of your choices, and you can direct and teach your child how to do better and to make those better choices so that he is not sitting in that seat in 18 years. I have many recommendations for sentences, and it is surprising that the alternate PSI actually recommends a higher sentence, higher punishment, both on the front end and on a back end if the court follows a recommendation of probation and if you are revoked. That was surprising. I have heard from, I believe, multiple people with the underage drinking ticket prior to, like a month or so prior to this incident. And I do take that into account. But then on the other hand, I do have to take into account all of the positive things you've been doing to change your life and to focus on substance abuse issues and or the traumas you've experienced to move on and move forward. I want Katrina's death to bring positive change, not only in you, but in the community, in our culture. Too many young people have been lost, and we need change. You have been provided the opportunity to be a mother, and you have been blessed. Katrina never will. Share this story with your son as he grows. Share the positives and share the negatives when he is at an age to be able to understand. Teach him to be strong. Teach him to know right from wrong. Teach him to know that you cannot self-medicate. You must seek assistance from professionals. You have learned that the hard way. I have heard from both attorneys the progress that you've made and hearing that the court should not sentence and do something that would derail you from your continued progress. And I agree and I understand that concept. But I also understand that a life was lost. There is a punishment factor. I cannot have a sentence that would cause more devastation. And I wish I could take away the pain of the family in a sentence without without thinking or believing that it could be detrimental and causing more issues with not only you, Miss Mitchell, but your son, your family. So when I'm looking at this case, what the court finds to be not justice, there's no justice. To be a sentence that not only is a hammer over your head, but it provides punishment for the choices you made that day. The choices that cannot be changed. What the court is going to do is, with regards to count 2, homicide by a negligent operation of a motor vehicle, a Class G felony. What I'm going to do is I'm doing an imposed and stayed sentence of 5 years of initial confinement and 5 years of extended supervision. That is the max prison sentence. But I'm staying that, and that is a hammer over your head to continue your path and your life choices in a positive way. I'm placing you on 5 years of probation. I am sentencing you to 1 year of conditional jail. 6 months is to be served in jail without the ability to have a monitor. 6 months is a drop in the bucket to the loss of Katrina. But it's 6 months that you will need to continue to repent and continue to know and figure out a plan to stay in your path, to change your life, to change your son's life, and to continue to take control of your future. After 6 months of incarceration, you may apply for an electronic monitor at your cost. And I believe that is now at $30 a day to be prepaid in monthly increments of at least 30 days in advance. Conditions of your probation. It will not happen this year on the anniversary of Katrina's death, but it must happen before the end, or before, it must happen then on every anniversary date and within 30 days of your release from custody, either on monitor or completely out of custody if you do not get approved to have monitor after 6 months. You must go to either the Webster, the Siren, or the Grantsburg School, or Lakota Ray, or any other Native American school on the anniversary of Katrina's death and speak of this tragic incident and what you have learned and how to prevent others from making these terrible choices that led to Katrina's death. No use or possession of any illegal drugs, substances, or paraphernalia. Absolute sobriety. No alcohol. No bars, taverns, liquor stores, casinos, unless it's for employment purposes only, or any establishments that have the primary purpose of the sale or the service of alcohol. You may not go into any of those. Again, casino for employment purposes. Regular testing, blood, breath, urine, or hair follicle, or any other testing as requested by your agent. No driving without a valid driver's license. If you do not have your driver's license, you must get your driver's license within 2 years from the date of today's sentence. The court is ordering that you provide your DNA. The jail. I do not believe this is one that your DNA can be expunged, but if you wish to request it, you may request it with the Department of Justice through a written letter to the Department of Justice, not this court. It's easy to do. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. You have until August 15th to get your affairs in order and then to turn yourself in to the Burnett County Jail. "20 days to appeal. If you fail to appeal within 20 days, you do lose that right. Is there restitution, Ms. Bauer?
No, Your Honor.
The court is going to order $518 in fines and fees, or excuse me, in fees. With regards to the matter, I'm ordering $1,000 in a fine. Actually, $1,000 to be donated within 2 years from today's date and time. To a charity, the family's choice, unless the family chooses not to participate, then to a program that shows or that teaches adolescents about distracted driving. Failing to pay your fines and fees and failure to have that charitable donation made means the court will, not only will the court enter a civil judgment against you as it relates to the fines and fees, but the court would issue a warrant and you could sit up to 6 months in jail. Your probation can be extended if you fail to meet your terms of probation, if you fail to make that donation, and or if you fail to pay off your fines and fees. I know in the family's mind, and even in Ms. Mitchell's family, that justice has not been served. Again, this is not an emotional process for the court. I must look at it rationally. Mr. Schmidt, am I missing something?
How long did the court give her to get her license?
2 years. She's not going to be able to?
DOT will revoke her license. It's unclear how long. That's what I'm concerned about.
All right, no driving without a valid driver's license. And she must get her license by the end of probation. Mr. Gondik, am I missing something?
I don't believe so, Your Honor.
All right. Again, 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court, again, believes that the sentence protects the public and instills both punishment as well as an incentive to continue to improve your life and to improve the life of others and to help deter others from similar actions. We are adjourned.
Okie dokie. So many people have so many things to say, but we're not going to hijack this particular live show to do that. But we will hijack Sidebar tomorrow at 8 p.m. Eastern, 5 p.m. Pacific. So join us then. Let's stare at our bear friend for a moment or two, shall we? Okay, friends, breath having been taken in our effort to provide 9 to 11% more Judge Boyd, let's go there.
All right. Christopher Medellin, correct?
Yes, correct.
All right. So today is your plea deadline date. Do you want a jury trial or a bench trial?
I'll try to see if I can get a different, court appointed counsel.
No. This is your court appointed attorney. So do you want a bench trial or a jury trial? Or have you all reached an agreement?
As I conferred with Duffy, he extended a new offer. I conveyed it to my client, let him read the file, aware of the discovery. I generously support his motion to get a new lawyer. I'm sure there are many better than me in the courthouse. And
I disagree with that.
To be effectively represented. So if the court wants to appoint somebody else, I
No.
will not be here.
No. Court will not be appointing you a new attorney. This is your attorney. If you want another attorney, you'll need to hire one. So my question for you, today is your plea deadline date. Have you reached an agreement? If you have not reached an agreement, then your plea deadline will have expired and your next setting is going to be a jury trial or either bench trial.
I mean, I have a little bit of time to hire an attorney in.
All right, your plea deadline date has expired. The court will not consider any plea bargains in this case without good cause. All right, do you want a bench trial or jury trial?
Jury trial.
All right, Ms. Ferguson, if you can give them a jury trial date, it should be short. It's a robbery. So I'm thinking, including jury selection, what, 2 days?
Well, there's a robbery, felon possession of firearm.
Okay, I just have the robbery. Is there another case? Let me see. That may be on a different docket for a different day. So, Norma, 3 days, jury trial. All right, you're coming back on September 23rd for your jury trial date. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. And Mr. Duffy, could you do an acknowledgement of discovery, please?
Get that right now, Judge.
Thank you.
September 3rd is for a board hour.
Yes. All right. And if you do hire an attorney, you need to let them know they need to be ready for trial on September 23rd. Do you understand? All right, thank you. Mr. Meyer, once you sign the acknowledgement,
Okay,
then you're excused with regards to Mr. Medellin.
thank you, Judge.
Thank you. All right, who are the parties on David Alonso Saldivar?
Present, Your Honor.
All right. State what is happening with this case?
Judge, we do have a proposition for the
Yeah.
court that would resolve everything, but it would include a withdrawal and an alternate amends for conditions to address certain issues, but it would take care of all of defendants.
And what are you all requesting with the alternate amendment?
For state ISF, inpatient address substance abuse issues.
And I believe that you were going to extend first.
There would be an extension proposed as well. And we have spoken with probation about this. For today's contested, this arrangement would allow for probationer to address these issues in a sense that the state would not be able to achieve today.
Ms. Abrams? On Mr. Saldivar? Yes. Thoughts?
I did speak with Duffy on Friday, and we felt like that was the best thing to do at this point.
All right, who's the complainant on the new case?
If the state may.
To answer that question, the complainants on the new number ones for family violence were his parents and sister.
And what are their names? What's your parents' names?
David, Elizabeth, and my sister's Angela.
And your sisters who?
Angela.
All South Florida.
So what is going on with him? Does he have mental health issues?
Yes, Your Honor, you, and initially, when he started probation, he's getting toward the end of that. But when you started probation, you originally ordered DDRF. However, he was bounced out of that. They was not qualified for whatever reason. And his family does want him to have, they understand that he has problems with illnesses and things.
Okay, you're trailing off.
Sorry.
I can't hear a word you're saying.
Mr. Saldivar understands that he has, and his family understands that he has substance problem use treatment. Also.
All right, so I don't know how state ISF probation, how is that going to address mental health issues?
I'm more focused on the substance abuse factor of it. I don't know necessarily.
Does it sound about?
Mental health issues. He has been or was on at one point in time to make caseload. I was just reviewing that.
I mean, would felony drug court take him or no? Because they have their dual diagnosis program.
Have to do a referral.
All right.
I think perhaps, Your Honor, Mr. Saldivar does have some anxiety issues. I think perhaps that the family thought that behavior may be more mental health related. However, it was those instances were all related to the influence
All right, so if he has anxiety issues, I don't know how he's gonna do well in ISL. Because I'm writing a different program than what you all have come up with. And if he has anxiety, then I don't know how he's doing at the jail. If he has anxiety, I don't know how he's gonna do in ISF. So that's something that they can address in their dual diagnosis program if they accept him.
Yes, Your Honor, you're talking about the felony drug court? Okay. Well, Mr. Saldivar does want treatment for his issues. It has been a little bit of a struggle for him being in jail. He's mentioned that, but he's working with the situation. We're just trying to tailor so that he's able to get the help he needs if family wants.
Okay, you keep trailing off.
I'm sorry, Your Honor.
And I
Sometimes I
can't
get
hear.
too loud.
No, you're not loud at all. You're trailing, you start here and then you go down and I can't hear the rest of it.
I apologize, Your Honor. We were just trying to tailor the situation so that he's able to get some, he's never had the proper inpatient treatment. And we were gonna try to tailor the situation to find.
Oh, felony drug court will tailor the situation if he is accepted. I mean, he has, here are your choices. Your choices are the state wants to withdraw the motion. They want to alternate amend your conditions. So the only thing that's going to end up happening is either you're going to get accepted in a felony drug court, you're not going to be released from custody, or either you're going to ISF and you're not going to be released from custody. So that's it. Now, if you want to, the state can proceed. You can plead to true to one of the violations and the court will hear if they have come to an agreement. But otherwise, your probation today is getting extended for 2 years. That's what's going to happen. If they're withdrawing and they want to alternate amend, it's going to be extended for 2 years. You're going to remain in custody. You're going to be referred to felony drug court while you're in custody. And then if they don't accept you, you're going to go to ISF. That's what's going to happen. And then you're going to be put on GPS and there's not going to be any in-person contact with David or Elizabeth or Angela. And you're not going to be living with David, Elizabeth, or Angela.
And Your Honor, if the family contacted me to get an affidavit for change to no harmful or injurious.
No.
No.
Because we're here and in this motion to revoke, it has terroristic threat ×3. And I'm assuming that's involving his family members. And then there's also an interfering with emergency request for assistance, which means somebody was on the phone, allegedly calling 911 and you stopped them from doing that. So, no. Or if those are going to be the court's conditions, or if you want to be revoked, you can plead true to something and the court will revoke you.
I don't believe we have any objection, Your Honor.
All right, so probation. Then the state is asking that the MTR be withdrawn. He's going to be extended for 2 years. And in custody, I want a referral to felony drug court first. And if not accepted, then the referral to ISF. And then, are you employed? Were you previously employed?
I'm working as I'm a painter. I was doing odd jobs around. I couldn't couldn't find solid employment because due to transportation.
All right, via bus.
It doesn't go up to Bernie. I mean, it gets a company. It's complicated.
So here's the thing. This is what people have to understand. I understand when people don't have transportation. I understand when people, the via bus doesn't run to certain locations. I myself, and I've had family members, guess what? When they didn't have a ride, they timed what time they needed to be at work and they walked. I mean, are we living in a society where we say we don't have a ride, via bus doesn't come here, so therefore I cannot work? I would love to do that, not work and still be able to afford to live like I want to live. Everybody needs to get a job. So there's going to be partial GPS for employment. waive fees,
Your Honor.
and that will be upon release. Is there anything else that you need from the court to be successful?
I had nowhere else to live with my family, or
Not gonna happen.
I don't know where else to go.
Felony drug court, if you're accepted, if you're honest with them, they will accept you and they will help you find housing. Do you understand? And there's to be no in-person contact with David, Elizabeth, and Angela Aguilar. I'm sorry, Angela Saldivar. And the reason why I'm doing that is because this could have really turned into something completely different. And then you would have been here for something that's more serious than just a terroristic threat. Once you are stabilized, then your attorney can always reapproach the court and I'll reconsider lifting it and making it no harmful or injurious.
Thank you.
All right, is there anything else you need?
Can I speak to them?
Sure. Yes. You just can't have in-person contact. That means that you can't go to the house. You can't see them face to face. You understand? But you can call them on the phone. You can even, and I say face to face, you can even do a video conference with them, but you are not to see them in person. Do you understand? All right.
And just for the record, Your Honor, I should mention that as part of the agreement to agree to extend the probation, the state's going to be filing with Middleton 2025 CR 008047.
All right. Once they give me the dismissal, I will sign it.
Yes, ma'am. Thank you.
All right. Is there anything else you need? Yeah, now's the time.
You can always call me too. You can always call me too. I'm
All right.
good. Thank you.
All right, you're welcome. And if you ever need anything, let probation know. And if you feel they're not addressing it, you can always come back to the court.
Thank you.
All right, good luck to you.
Thank you.
You're welcome.
Okay, so before we move over to the next court, another reminder that tomorrow's show is show number 100. And again, I can't believe it's 100 already, but this is the show that you definitely want to be on. And if you've been trying to figure out how to convince family or friends that they should check out the show, just tell them tomorrow's the show they need to be at, because I'm going to give you guys something new that will forever change how you interact with this show, and it will incredibly broaden its appeal, in my opinion. And from the people I've showed it to, I think they would tend to agree with that. So be sure to check us out, 10 a.m. Eastern, 7 a.m. Pacific tomorrow for episode number 100. Let's stay in Texas, but we'll go to Judge West, who should be having her standard Monday parade of fashion.
God, it takes forever. My computer's running slow. Give me a minute. In cause number 250358, you're charged with the second-degree felony offense of burglary of a habitation, and that's from February 20th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? How old are you?
18. I just turned 18 in June.
You did? Are you working? Are you in school?
No, ma'am, I'm not working, and I'm supposed to re-enroll into Paul Brown whenever school year starts.
Okay, if I test you this morning, you gonna have anything in your system?
No, ma'am.
Let's double check that, and then we'll see what we get worked out. Have a seat over there in the jury box. Michelle Johnston. Good morning, you're Michelle Johnston?
Yes, ma'am.
And Ms. Johnston, did you get someone hired?
I did. Y'all called him last time and he said he was gonna do everything, but I've had trouble with him before.
Who?
John West.
Okay.
At this point, I really don't even think that I need one because I have all the proof showing that I paid everything.
Well, the thing is, I can't take that information and do anything with it. Did you pay him money?
Not yet because he's.
So here's the thing. He's not hired until you actually sign a contract, pay him money. So he's not going to show up in court.
Mm-hmm.
So if that's not going to work out and you're having trouble getting in touch with him, then did you talk to some other attorneys?
No, ma'am, because I figured that I could just do it myself, seeing as I have everything. and I don't have the money to pay one. I always had a payment plan with him.
This is
Because when
Mr.
y'all called him, he said that he was gonna do my representation last time I was here, the first time I was here.
Right, but I can assure you, no one is going to represent you unless you pay them. That's just not how it works. Let's do this. Brittany's gonna be here on regular docket, right? Stay here. I'm gonna have Ms. Holmes, who was appointed to represent you while you were in custody, visit with you this morning, see if she can visit with the DA, and if it looks like something could get worked out, great. If not, then you're gonna need to talk to some other attorneys, and we'll talk about that.
Okay, because that's what it was supposed to do while I was in federal prison.
Okay, just have a seat in the courtroom. Don't leave until you talk to Ms. Holmes and we tell you what to do. Makisha Victoria. Good morning. Are you Makisha Victoria? Miss Victoria, did you get someone hired?
I'm just $25 short now, you see, so it's almost.
You're what? I'm sorry?
$25 short now, it's
Okay.
out, so I can't, it's now.
Okay, so, and who were you hiring?
Rice Kemper.
Okay, and so if I give you a couple of weeks, you'll be able to get that taken care of?
Yes, ma'am.
Okay, I'm gonna reset 2 weeks. You need to get that taken care of before the next court date,
Yes,
okay?
ma'am.
All right, step in front of the clerk. She'll give you your reset notice. Monique Nguyen. Good morning.
Good morning.
Are you Monique Nguyen?
Yes, ma'am.
Miss Nguyen, did you get someone hired?
No, ma'am, actually, I've been calling around. But one of them said that they can't help me because I have too many cases, too many charges, and then all the other ones, they only have 10,000.
Who'd you talk to?
James Makins. Will Hall is the one who said, we're the court. Hall is the one who said he can help me in Franklin. Then I called, my attorney, Brittany Holmes, to see if she could represent me, but, she said that y'all gonna have to do that.
Okay, so I mean, you can, all right, are you working?
No, not yet. I'm gonna start by working, when I put, my kids in school, I have no babysitter right now.
All right, so thank you for talking to the lawyers like I asked you. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're gonna swear under oath that everything's true and correct. Step in front of the clerk and she'll give you that paperwork. Are you by yourself? Okay. Daryl Albritton? Daryl Albritton.
Daryl, already?
I think
No response, Your Honor.
this bond will be forfeited for non-appearance and reset at 100,000. Roderick Anders? Good morning, you're Roderick Anders. And Mr. Anders, did you get someone hired? Who'd you talk to?
Robert Thompson, James or Macon. Carlos Rojas.
What's the last one?
Carlos Rojas.
Say it again?
Carlos Rojas.
Oh, okay. And so where are you on being able to get someone hired?
I can't afford it right now.
Are you working?
Yes, no.
Where are you working?
Dollar Tree.
Okay, so I'm gonna have you fill out some paperwork this morning. Thank you for visiting with attorneys. I'll see, put all your income, any bills you have, make sure you fill that paperwork out accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk, she'll give you that paperwork. Mark Garcia? Okay, if you'll go ahead and call the name, Mark Garcia, and then if he gets here, I'll, okay. And Summer had one too on the regular docket that just called. That McCorvey on page 8.
Can I call it name, Judge?
Yeah.
Martin Ward.
No. It's reset. It shows reset
Oh, is it?
on my docket. It's on page 3.
I think he has a lawsuit because the county. No response.
All right, his bond will be forfeited for non-appearance and reset at 100,000. He did call and say he was having car trouble, so if he gets here, I'll recall that.
Okay.
Gerald Jackson.
He called the bondsman said he's having car trouble as well.
Nobody's card. Gerald Jackson.
Gerald Jackson. Gerald Jackson.
Does Ryan know about his client's issue? At the top of that next page.
Hey, Ryan.
All right, his bond will be forfeited in all 3 cases and reset at 100,000 in each. He also apparently said they are having car trouble. If he gets here, we'll recall that. Shay Morgan.
That's my new client, Judge.
Okay.
She called this morning and said she's running late.
Okay.
We also know she's got a separate issue.
All right.
Make her aware of that, so.
If you'll go ahead and call the name Shay Morgan, please. Thank you, Mr. Gertz. I'll go ahead and do the bond forfeiture, but then if she gets here, I'll recall it.
I've not met her in person, so I don't know what she looks like.
Okay.
Whatever that's worth. She's probably nothing.
We'll see.
Make
Nobody
sure
wants
she
to.
gets here. She's at least in communication with us, that's.
No response, Your Honor?
Her bond will be forfeited for non-appearance and reset at 100,000. If she gets here, we'll recall that. Goodness gracious, nobody wants to come see us today. Lance Charbino. I know. Good morning. Are you Lance Charbino?
Yes, ma'am.
And Mr. Charbino, were you able to get someone
I
hired?
had called Crenshaw Law Firm and Franklin and Associates. I'm wondering if I can get a 2-month extension because I start 7/12 next Monday to be able to award me one.
Okay, so I always do 30-day resets. So what I'll do is, since you're giving me that information, you've talked to some attorneys, I'm going to do a 30-day reset. When you come back, let me know where you are on being able to get someone hired, and if you need that one more reset for it, then we'll try to get that taken care of, okay? All right, if you can step in front of the clerk. Shaniqua Washington, and if you'll make a note on there for me, just so maybe I'll remember. Well, just that he's starting 7/12 and should be able to hire someone within 2 resets. Have you decided which one or who you're gonna hire yet?
I haven't decided exactly which one, but I've been talking with Crenshaw Law Firm a lot.
Okay.
And they sound pretty promising.
All right, just make sure you get that, at least have it narrowed down to who it's gonna be next time.
Yes, ma'am.
Okay.
No response, Your Honor?
Good grief. Her bond will be forfeited for non-appearance and reset at 100,000. Christian Ainsworth. Good morning, you're Christian Ainsworth? And Mr. Ainsworth, were you able to get someone hired?
I don't have it right now. I don't financial hardship in 2 months.
Are you working?
Yes, ma'am.
Where are you working?
Raising Cane's.
Okay. Did you talk to some attorneys like I asked you to? Why?
Busy, and if you remember, it's the last time my mom passed away, so I had to pay for partial of the funeral, so I was thinking, I don't need the money, so why?
But you don't know if you can afford or what you can afford until you talk to some of them. That's the whole point. And I understand that you had that loss and we worked with you last time, but you've got to get busy, at least do what I ask you to do. Otherwise, you're going to end up going to jail. And so I'm not sending you to jail because you can't afford somebody, but I'm going to send you to jail because you're not following my rules. And I said, this is a court order. And if you don't follow the court order, your bond could be raised for not following that court order, right? You have 30 days. You either get somebody hired or you talk to at least 3 lawyers in person and you bring me those names, or you will go to jail for not following that court order. Do you understand? Step in front of the clerk.
Sorry, Judge.
It's like I'm hearing an echo of myself. Danelle Coleman.
I get it before the 30 days, can I come out now?
If you get what, a lawyer? If you get a lawyer before the 30 days, just give that reset notice you get to them and they'll send us notice and it'll probably take care of that court date and you'll get reset out some for a different type of court date. Good morning, ma'am. You're Donnell Coleman. And Ms. Coleman, were you able to get someone hired?
Thank you.
Who'd you hire?
The
Okay.
guy that was appointed to me when I was.
And you went and hired him?
Yes, and he actually, because I told you I had just started working again.
Uh-huh.
So he was actually willing to walk down the normal cost they do for cases like this.
And did you already pay him or you need some time to do that?
I'm partially paid him. I still have a little more, but
Okay.
I still get paid every week.
Okay.
But he even bumped the price down for me to work again.
And that's Mr. Rojas?
Yes, ma'am.
Okay.
Oklahoma Calder.
Uh-huh. Okay. Mr. Rojas, that sound familiar?
Yes, we talked on Friday. No, not yet. You told me to.
Yeah.
I think you said.
We talked about making cuts with a lower amount. Yeah, but you haven't made that payment.
Not yet. I will be making it on Thursday.
On this Thursday? Okay, so I'm gonna do a 30-day reset. Make that first payment or do whatever you need to do. Bring me a receipt, if you haven't hired him all the way by the next court date. If you do get him hired before the next court date fully, then, just stay in touch with him and he'll take care of that court date and tell you when to come. Otherwise, make sure you're here when we tell you, okay? All right, step in front of the clerk right here. She'll give you a reset notice.
Fashion seems fairly under control with Judge West's court this morning. Not the most outrageous we've seen. Let's stay in the building and we'll spend a moment with Judge Stevens. Or not, because he's muted. He
Had an
does that to me all
opportunity
the
to try
time.
to.
Whoops, and she's not muted. Let's continue with her though while I figure out what's going on with Stevens.
Okay, how much do you receive a month?
$3,064.
Okay. Did you happen to bring any proof of that with you?
What, my disability?
Mm-hmm.
I can show you where the deposit is.
Okay, that's right. So what I'll do this morning, Mr. Jones, because of that, is give you a court-appointed lawyer. If you'll step in front of the clerk, she'll let you know who that's going to be, and if you have it now, that's fine. If not, okay, step in front of the clerk. Ronald Souls. Good morning, sir. You're Ronald Souls. Did you get a job?
Yeah, not yet, Your Honor. I've been working on it. And I did talk to my understanding, I had, my girlfriend had talked to him. Like, I think he was my first offender.
Uh-huh.
But he had told us to continue to do what you had assigned us us to do, and I talked to another lawyer, and I'm supposed to be done hiring him Tuesday.
Who's that? Just who is it?
Kim, Rice Scott.
Rife Kimler?
Yes, ma'am.
Okay, and you intend to hire him
Yes, ma'am, Tuesday.
this tomorrow, as in tomorrow?
Yes, ma'am.
All right, so I'm gonna reset your case for 1 week to next week. If you get him hired this week, bring that reset notice to him. He'll tell you what to do. If he tells you, you need to be here next week, then be here. If he gets a new court date, your bondsman and him will let you know. Otherwise, be here next Monday with proof that you've hired him, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you, your reset notice.
All right, it looks like Judge Stevens might maybe have unmuted now. Let's try again.
I think, Mr. Johnson, you pleaded guilty on
Yes, sir. On
June 23rd.
Yes, sir.
You may send that paperwork to Judge.
I sent it.
No, it's in my queue.
Okay.
I'm looking at this.
There's some stuff. You were. Except it was one thing. And it was a new building. This race to this kind of burning down. And they really fun. Probation.
Unmuted, yes, but buried in paperwork. I really wanted to hear what he had to say today, but maybe tomorrow because we're only got like 15, 20 minutes left. Let's go back to Judge Boyd.
Tariana, please.
Your Honor.
Hello. All right. Just one moment. All right, so you had a chance to meet with your attorney?
Yes, ma'am.
Okay. All right, Ms. Ferguson. If I can have a 3-week reset for discovery. All right, so we'll come back on August 19th for discovery, and state you need to be prepared to tender an offer.
I tendered a global offer this morning to the council.
Okay.
But I would like to review the discovery before we.
So we'll put the discovery at August 19th. The court will note that the defendant has all of the discovery, and the court will note that an offer has been tendered.
And there was one other matter, Your Honor.
Yes.
I believe he's remand right now.
All right. Is there a reason for the remand? Do you know?
Well, I think what happened is that he violated one of the conditions of his bond by looking for work without permission. Tells me that he called 25 to 30 times. His officer couldn't get anyone, so he decided that in desperation to look for work. And in the process, the monitor went off, of course, and he got a violation for violating the monitor.
All right, you'll need to set it for a hearing.
Okay.
Because I need to see exactly what the issue is, and then the court will hear it.
Very good.
Just speak with Ms. Ferguson about that.
I will.
All right, thank you. All right, who is here on Jesse James Lewis? And there are no applications. All right, court is calling 2025 CR 007751 and 2025 CR 007752, State versus Jesse James Lewis. Could I have parties announced?
Megan Galloway for the state.
Glenn Payne for defense.
And are you Jesse James Lewis?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lewis, did you review the true bill of indictments with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictments?
Wait.
State in cause number 2025 CR 007751, are you proceeding on the indictment as presented?
Yes, Your Honor. And the cause number ending in 7752, we are waiving the enhancement.
All right, any objections to the waivers?
No objection, Your Honor.
In each cause number, Mr. Lewis, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
In the cause number ending in 51, you're charged with unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. In the cause number ending in 52, you're charged with evading arrest detention with a vehicle with a previous conviction or SBI is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have plea bargain agreements with the state, the court does not have to follow your pleas. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering these pleas, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
In each cause number, counsel, has your client been able to provide you with any defenses?
We discussed the cases and no defenses that we can present to the court.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
My opinion, yes.
Mr. Lewis, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement and the cause number ended in 5-1, punishment is to be assessed under 1244 at 94 days in the Bexar County Jail. There's a $2,000 fine. Cases will run concurrently, and the state will take in consideration 2025 CR 007750. In the cause number ending in 5-2, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. Cases will run concurrently. The state will take in consideration 2025 CR 007750. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2025 CR 007751, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And cause number 2025 CR 007752, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offer states one in attachments.
Your Honor, I review these with my client. We have no objection.
All right, state you may be excused. Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same for sufficiency. We can go off the record.
Okay, while she's off the record, one more reminder to join us tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, for our 100th episode. I'm really looking forward to it. I'm kind of geeked about what I have for you guys, and hopefully you like it. But again, it'll be tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. We are just a little bit in the Wayback Machine here with Judge, so let me see if I can nudge her forward past her off-the-record moment here. There we go.
Just don't have the good music anymore. You know, I was listening to Sly Family Stone this morning. Thank you. I love that song.
Oh, thank you.
Yeah.
I love the song If You Want Me to Stay by them.
Yeah.
That's a good one.
Thank you. All right, the court will review states exhibits 1 and attachments for sufficiency, and state you may be excused. Thank you. All right, in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client, both what case he just asked the court filed for plea bargaining written.
All right, in cause number 2025 CR 007751, the court is finding you guilty. The court will sentence you to 94 days in the Bexar County Jail under 1244. Give you credit for any time served. There's a $2,000 fine. This will run concurrent with 2025 CR 007752. Take in consideration 2025 CR 00750. And there's to be restitution, if any, to Sally and ANE Pryor. Is there anything with regards to sentencing under that cause number? Counsel?
No, Your Honor.
Cause number 2025 CR 007752. Court is finding you guilty. Court will sentence you to 3 years in the prison. Credit for any time served. There's a $2,000 fine. This will run concurrent with 2025 CR 007751. Take in consideration 2025 CR 007750. And there's to be restitution, if any, to Sally Ann Pryor. Anything else with regards to sentencing and under that cost number?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal in each of these cause numbers?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
22.
All right, so you're gonna have to make a decision. Do you want to live the rest of your life in somebody's prison? Because let me just tell you, no matter how much money the state says they do not have, how much money they run out of, there's one thing they always have enough money for. And you know what that is?
Prison.
Prisons and jails. So you had better change your ways. Otherwise, you're gonna spend the rest of your life doing that.
I don't know. I'm learning.
And here's the thing, I have no problem with tattoos, but if you do face tattoos, your employment opportunities are going to be limited because people see that. Some people don't like it. Some people are fine with it. Yeah, you're okay with it if you're planning on playing in a band or something, but otherwise people are going to say, nope. All right.
Yeah.
All right. Good luck to you.
Thank you.
You're welcome.
She's not wrong. All right, friends, this is the logical place to leave it for today. I hope you all had fun. I know I did. It was a heavy day, but enjoyable to watch the courts and spend the time with you guys nonetheless. So we'll be back tomorrow. Big slate of programming for you tomorrow. Obviously, the 100th show at 10 a.m. Eastern, 7 a.m. Pacific. The pre-show a half an hour before that. If you are a channel member, attend the pre-show because you will get a heads up on what we're debuting during the live show. So you want to be there for that. And then we have Sidebar tomorrow night, 8 p.m. Eastern, 5 p.m. Pacific, where we chat. It's me and Bailey and Ashley and Michael, and we have fun. So you want to be there for that as well. Do go have yourselves a great Monday. I look forward to seeing you all tomorrow. Take care of yourselves. Make it a great one. Take care. God bless.